Well, good morning, everyone, and welcome to Aj111 Criminal Procedure. My name is Tony Farrar, and I am, of course, your instructor for this semester. By now, you should have already gone through the first module or week one and have completed the syllabus review, the syllabus quiz, and have watched the lecture. So you should be ready to go ahead and jump right into it, and that's what we're going to do. So we're going to start off this morning by going through chapter 1, a introduction to criminal procedure. I'd like to start by outlining some of the learning objectives, meaning what do we hope to take away from today's lecture? Well, first, I hope we can be able to understand the difference between criminal law and criminal procedure. Next, we hope to be able to specify how criminal procedure strikes that balance between the interests of, let's say, investigating and detecting and convicting criminals on one hand, and the interest in protecting the right of individuals to be free from intrusions into their privacy and liberty on the other hand. So how do we balance those two things out? Next, hopefully we can have or develop an appreciation for the objectives of criminal procedure, meaning what are the objectives? What is criminal procedure all about? Next, to know the sources of criminal procedure, meaning where do we find it or where do they come from? So think about that. Also, to be able to define the word precedent, not president, precedent, and the role of precedent in judicial decision making, meaning does the U.S. Supreme Court fall back on cases that have already been heard in order to help make decisions on current issues that are similar? And the answer to that is yes, and we'll learn a little bit more about that. Next, to be able to know the different philosophies or the different philosophical perspectives of the judges. And you know, because we're all human beings, they are too, and they're going to have their own little thought process on how they're going to evaluate some of the cases and the different perspectives that they each have. And then finally, to be able to understand the difference between law in action and law on the books. And we'll talk a little bit more about that as we go through the chapter. So with that said, I'd like to have you look at this picture, and I want you to kind of think about it on what it really means to you. And if you don't know what the photo symbolizes, this is Lady Justice. And one of the unique things you can see is that she has the scales of justice out in front of her. And those scales, again, if we go back to one of the objectives, is that balance between the interest of investigating and making an arrest and convicting a criminal against the interest of protecting the rights of others. So that's part of how the criminal justice system really is supposed to work. Now, the other interesting thing, if you haven't kind of caught it already, is that you can see that Lady Justice is blindfolded. And it's not because she is striking the piñata, okay? It's because the philosophical thought is that justice is blind, meaning that it's supposed to be fair and impartial across the board. And we're not supposed to choose sides or favorites or cliques or any of that other stuff. And one of the things that has come about to kind of help us do that is when you look at this whole structure of how not just the court system, but how everything goes together, you're going to see three distinct pieces. And you're not going to see one person or group in charge of all of them, because imagine if you were judge, jury, and executioner. Could that work together if one person had the responsibility to make all of those decisions? Well, the way that our U.S. justice system is set up is you have law enforcement is one component, you have the courts as the other component, and then you have corrections as the other component. So even those are separated. And if you want to learn a little bit more about the structure of the court system, you can click on the link that I have there. Or if you go back to the introduction module, right before that introductory part, there should be a video on each of the different court systems, whether it's the local court like the state court or the Court of Appeals or the state Supreme Court or the U.S. Supreme Court, etc. So all of that will be available to you if you want to watch some videos on that to get a little bit more information. So by way of introduction, criminal procedure may seem like a topic that has little relationship to your life and experience, but that's really not the case. Anyone who has ever been, let's say, stopped by law enforcement, searched, questioned, arrested, or even prosecuted for a minor violation likely has wondered whether or not things were done appropriately within the confines of the law. And, you know, you can go a little bit further and say, were there any types of violations of law, whether the police or the citizen, in fact, acted in a lawful fashion? So again, there's a lot more to this criminal procedure, and the answer to what I just said can be found in the body of law that falls under this category of criminal procedure. So what we want to do now is look at some good reasons to study, or why we should know criminal procedure, why you took this class possibly. So the first one would be what we call practical usefulness, and the study of criminal procedure helps you understand your rights on the street and in court. Now, again, and if you've taken one of my classes, you know I'm very outspoken on both sides of the fence as far as law enforcement, citizen rights, and everything, you know, kind of in between. And I'm not going to say that, you know, law enforcement is perfect, but honestly, about 99% of the time, things are done correctly, but they're not always done correctly, and I think we all know that. So again, the study of criminal procedure will help you understand your rights on the street and in court, if that's a place that you end up in, or what have you. Next would be professional usefulness, meaning that anyone who plans a career in the criminal justice field should know about criminal procedure. So if you look at the list I have here, everything from a judge, you know, to computer forensics, to cybersecurity, to defense attorneys, to criminology, terrorism, FBI, police, sheriff, corrections, everything, you need to know how this criminal procedure impacts your job. And it's going to, and we'll look at that as we go through the semester. We'll take a deeper dive on some of this, and some examples again, just to kind of show you a visual, you know, whether or not, again, whether it's a family court thing, or whether it was the O.J. Simpson trial, if you remember that in the upper right, or whether you're working for parole, probation, corrections, or whatever. All of that, criminal procedure plays a role in all of that. The next one would be understanding the Constitution, the U.S. Constitution. So judicial decisions on criminal cases help you understand the various provisions of the U.S. Constitution and the principles of American democracy. And if you don't know, when we talk about the provisions in the Constitution, we're going to talk a lot about the Bill of Rights, which is what? I'll give you a second. In your head? Okay, so it should be the first 10 amendments to the U.S. Constitution, and those have a huge impact. And you could throw the 14th in there if you want, but all of those have a huge impact on the way that you are going to do your job, and how judicial decisions on cases are both understood and made. Next would be insight into those specific judicial decisions. So judicial decisions on how criminal procedure provide insight on how judges decide cases. Now, there's a phrase out there, and we touched on it in the learning objectives about precedent. Well, there's another word for that. It's called stare decisis, and there's a couple of different pronunciations, but I'm going to go with that one. And really what it means in Latin is let the decision stand. And what this does is this precedent, this case study, this stare decisis, if you will, means that judges will look at previously completed cases to help them decide similar issues. And that'll make a little bit more sense as we start to go along. And then finally, comprehension of public policy. And that really means that criminal procedure is an arena where important issues are debated and decided. And one of the interesting ones, if you look over to the right and you can see the case right there, this is the petition for a writ of certiorari going up to the United States Court of Appeals. And really what this is the Carpenter versus U.S. case regarding cell phone information and being able to track your cell phones. And that's important if you are concerned with privacy and government tracking you and different things like that. So again, public policy and there are a lot of issues that are constantly debated and decided. So now that we know the importance, let's talk a little bit more in depth on criminal law and criminal procedure. So a couple of different examples of the type of things that we're going to go over. The first one is what they call substantive criminal law. And substantive criminal law defines the factual elements of criminal offenses. So to convict a defendant, the prosecutor is required to prove the required criminal intent and criminal act and resulting harm beyond a reasonable doubt. And we'll learn more about those different levels of burden as we go through the course. So, for example, a conviction for robbery requires that the prosecutor establish the elements of that, the intentional forcible taking of property from another person with the intent to permanently deprive the person of the property. So when we talk again about substantive criminal law in the realm of criminal procedure here, it defines the factual elements of the offenses. In essence, the elements. Now, on the other hand, as we go a little bit further, well, we talked about this a little bit. To convict a defendant, the prosecutor is required to prove the required criminal intent and criminal act and resulting harm beyond a reasonable doubt. So you have to be able to prove all of those pieces. Criminal procedure, on the other hand, addresses the procedures involved in the investigation. Not the elements of the crime, but the procedures involved in the investigation, the detection, and the prosecution of criminal offenses. So, for example, here in the case of the robbery, this may entail not the elements of the crime, okay, but the procedure, how we do it. So the interrogation of suspects, the identification of suspects, the searches for fruits of the crime, let's say weapons, and the arrest and prosecution of the suspects. So going back on a quick review, substantive criminal law defines the factual elements of the criminal offenses, where on the other hand, criminal procedure addresses those procedures involved in the investigation, detection, and prosecution of criminal offenses. And we know that, as we talk a little bit more, the enforcement of criminal law is then going to be influenced by criminal procedure, because there's some rules and some guidelines, which means that we have to follow those. So criminal procedure regulates the authority of law enforcement to stop and search people, to interrogate suspects, and to conduct lineups. So it regulates the authority, as I said, of police and other actors in the system, meaning it could be corrections or anything in under the umbrella of, let's say, the three things that I looked at: law enforcement, courts, and corrections. And it also hits on the aspect of civil rights. Okay, knowing that the American system of criminal procedure reflects a faith that fair procedures will result in accurate results. So we've got, again, the balance here between civil rights and the investigative process. Now, before we jump into some of the other aspects, looking more at the objectives of criminal procedure, I wanted to touch on really quick the burden of proof before we get too far into the lecture, because I know this always tends to come up. And when we talk about burden of proof, and we'll learn more of each one of these in different chapters as we start to go through. But think about what burden of proofs might be. Like an example would be, what level of burden of proof do I need just to stop you for any type of an investigation, or to search you and arrest you, or to take you to trial and convict you? All of those are going to be different levels of burden of proof. So the first one is reasonable suspicion. These are the three that we're going to kind of look at really quick: probable cause and proof beyond a reasonable doubt. And I put them in this order so that way you know that reasonable suspicion is kind of the lower one on the ranking system, if you will. Reasonable suspicion is where a law enforcement officer would need some articulable facts to conclude that an individual is involved in some type of criminal activity. And that would be, so a traffic ticket, if you change lanes abruptly and an officer saw you do that and you didn't signal, there would be some reasonable suspicion that you broke the law, so they could pull you over. Probable cause is the next one. That's a higher level. And this is what you would need to actually search, seize, or arrest. And then finally, proof beyond a reasonable doubt is what you would need in the courtroom, where you would need that to convict someone. And the reason that the burden is so high is because you don't want to wrongfully send someone to prison, of course, so the burden is as high as it can be. And there's a couple of charts that I put in here for you that you can kind of look. And there are some other burdens that fit in there because remember, there's civil law and there's criminal law. And we'll get to some of the civil stuff later. But you can see that beyond a reasonable doubt is at the top of the pyramid. And it's basically the elimination of every reasonable doubt. We have probable cause, which would be facts and circumstances that lead an ordinary person to believe that this person was involved in criminal activity. But you need probable cause to search, okay, and arrest. And then the reasonable suspicion, that's enough just to stop and do a quick detention to investigate a crime. And this would be specific facts, as I said before. And there's a couple of different ones with the wording a little bit different, so I thought I'd throw that in here. Again, reasonable suspicion is that reasonable basis. Probable cause, okay, and then, of course, the beyond a reasonable doubt. And there's even a ladder that somebody put together that kind of shows the same thing. But hopefully that's just a quick overview, and we'll talk more about these as we go through the lecture. Okay, so now, again, let's jump back into it, and we'll talk about balancing security and rights, because we know that's important. So the American system of criminal procedure reflects a faith that fair procedures will result in accurate results. And sometimes the system looks broken when those who appear guilty rely on what we would call, let's say, a technicality to gain their freedom. There is nonetheless a strong belief that individual freedom is best protected by detailed rules and procedures. And the reason that I bring this up is because it's important to know that in all parts of the system, we are to follow those parts of the system for a reason. And if we violate some of those rules, then we have to be held accountable for that. And one of the things that could happen is a defendant could be released because maybe you did an illegal search or an illegal seizure. So again, we have chosen to create a justice system in which individuals in power are required to follow the law rather than a substandard system in which those in power are free to act as they see fit. Now, the requirement that the police in most cases are required to obtain a search warrant, let's say before entering your home, protects you against law enforcement conducting searches because they have a hunch or intuition. Now, of course, a system of criminal procedure that places too many legal barriers in the way of the police and the prosecutors will then frustrate the arrest and conviction of the guilty, while a system that places too few barriers in the path of the police may lead to coerced confessions or unnecessary searches or false convictions. So in the United States, there's an effort to create this system of criminal procedure that again strikes that balance between the interests of society in investigating and detecting crime and convicting criminals with that of individuals' freedom from intrusions into their privacy and liberty. So hopefully that kind of starts to sink in a little bit now. And as we start to go a little bit further, I want you to, we're not going to go through these individually, but these are, when we talk about the first 10 amendments to the U.S. Constitution, the Bill of Rights, a lot of them are going to impact you, none more than what you're looking at in front of you right here. So we know, you should know what all the 10 amendments are, but when we talk about criminal procedure, specifically the Fourth Amendment, what is it? If you said search and seizure, then you're right on track. It's unreasonable search and seizure. Doesn't mean that you can't search and you can't seize. So it's protection against unreasonable. Fifth Amendment, things like double jeopardy or self-incrimination. Sixth Amendment, right to have an attorney and right to a trial and right to subpoena people to court to testify on your behalf, etc. And then the Eighth Amendment, the cruel and unusual punishment. So again, that's just parts of it. So take the time to go through those because these are 4 of those 10 that are going to significantly impact what you do. And think of this case because this is always a great case to look at. It's old, yeah, but it's a great case when you look at the trial of O.J. Simpson. And I believe this is going to be in one of my classes. We're going to do a case study on it, but it's an extremely interesting case, not just from the arrest and the evidence, but from the criminal procedure portion, from the trial portion. So again, a great case study to look at. So again, balancing security and rights, we've chosen to create a criminal justice system in which individuals in power are required to follow the law rather than a system in which those in power are free to just kind of run amok and do whatever they want. And you can see the line between, you have ethics on one hand, the law on the other, and that middle portion, that's the middle ground. That's where things are ethical and legal. And, the balance between due process and crime control. Again, the interest of society in investigating and detecting crime and in convicting criminals against the interest of protecting the rights of others. And some of the pictures that you see there specifically when you talk about Florida New York or some of the other larger police organizations that use things like stop and frisk. It doesn't mean it's a bad thing, but it certainly has the possibility to be abused. And it is also big when it comes to criminal procedure. So, what are the objectives? So, in addition to balancing security against the interest of the individual, the American criminal justice system seeks to achieve a range of other objectives. Now, most of these values reflect the essential principles of American democracy. So keep these goals in mind as you go through the textbook, right? Because I know you're going to read the textbook. Of course you are. And think about the issues presented in each chapter as you look at these different objectives. So objective 1 would be accuracy, meaning that the innocent should be protected from unjust convictions, the accuracy component, and the guilty should be convicted. So there is importance in accuracy. Efficiency. The criminal justice system should process cases in a reasonable period of time so that individuals do not have the threat of prosecution hanging over them, meaning it shouldn't take 10 years for a case to go to trial. And you know, having that hanging over your head. So things are supposed to be proficient. So efficiency is one of the objectives of criminal procedure. The next one, respect, in a sense of the dignity of defendants and victims should be respected. And keep this in mind, and we're going to kind of pound this into everybody. If you don't know the phrase, I'm sure you do. You know, you are innocent until proven guilty. It's not the other way around. You're not guilty until proven innocent. It would be interesting, but it won't work. You are considered innocent until proven guilty. Therefore, the dignity of defendants and especially victims needs and should be respected. The next objective, fairness. Individuals should view the criminal justice process as fair. Well, I'll take 10 seconds out of this lecture and ask you, do you think our justice system is fair? Just think about it. Equality. The same quality of justice should be provided to both the rich and the poor and to various ethnic and racial groups. Do you think somebody that has more money that can hire their own attorney or attorneys is going to have a better chance at getting off of whatever they've been arrested for versus someone who doesn't have any money and can't hire an attorney, where they get a court-appointed attorney? So equality, it is important. And in a lot of the trials, those that have money, there is a disparate, kind of a disparate gap, if you will, when it comes to equality. Adversarial. Defendants should have the opportunity to be represented by attorneys at crucial points in the criminal justice process, and there are rules. So if you're going to be subjected to, let's say, interrogation, you can request an attorney, and the attorney has to be there before you have to give any statements. The attorney would have to be there possibly at an arraignment, or if it was going to be a live lineup, you have the right to have an attorney present. These are all considered crucial points in the criminal justice process, and not just the actual trial itself. Participation, there's a strong commitment to participation by citizens on juries. Have you ever sat on a jury? Or are you one of those, and I know you're out there, you can't hide, that when you get your jury summons, you just don't go, or you make up an excuse? There's a reason, and we'll talk about that later in a different chapter, on selection of jurors and why it's important that you serve on a jury, and that we have a vast variety, cross-section of the community that sits on juries. Next, appeals. An individual's freedom should not depend on the decision of a single judge or jury, and the reason for that is because sometimes mistakes are made, let's say. So there are appeals that are provided to ensure the defendant's convictions are reached fairly. So if you're convicted of a felony in state court, if you don't like the outcome, you can always appeal your conviction. It doesn't mean the next court has to take it, but there are opportunities for you to have another court look at it to see if things were done correctly. Next, justice. The aim of justice is, to provide justice for defendants and victims to help ensure a just society. So, justice is a big part of it. All these goals, if you will, form a criminal justice system whose procedures and results aim to provide justice for defendants and victims, and hopefully at the end of the day ensures what we would like to have, which would be a just society. Now, this is where things get a little bit tangly, and I'm not sure if that's a word, but okay. When you look at the criminal justice process, and that's where we're going to kind of get into things now, it seems simple, but if you look at the diagram that I put in there, it's not always that simple. So what you have in front of you is kind of a schematic, if you will, that walks you through the sequence of events in the criminal justice system. So a criminal felony in the federal criminal justice system progresses through a number of stages that are outlined below. I think I have a bigger one. Okay, here we go. And you can kind of look at it, and we're not going to spend a lot of time, but if you start on the left, you can see the crime, and again, it's every step. So this is the entry point into the system. Crime, the reported, the investigation, the arrest. Charges filed. Is it a misdemeanor? You go this way. Is it a felony? You go this way. And there's all these other things that happen, like your initial appearance, a preliminary hearing, a bail hearing, or are charges dropped. Misdemeanor can be the same thing. If you're a juvenile, you could get diversion, or you could go to juvenile court, or, again, a misdemeanor, it could be over here. So, and then when you start to get through here, then here's where the court picks up. Okay, so you've got all the charges, you've got the prosecution and pretrial, and then the adjudication part, which is like the trial or the guilty plea or acquitted or etc. And then you have the sentencing and the sanctions and the orange, and then the corrections takes over if you end up going to jail or what have you, or even if you get like probation or whatever. So look at all the different things. So it's complicated. So don't let anybody tell you that it's really not complicated. Now, keep in mind that this process is somewhat different in the federal criminal justice system than it is in the state system. So they're kind of close, but a little bit different. The striking feature of the criminal justice process, again, is the number of procedures that exist to protect individuals against unjustified detention, arrest, prosecution, or conviction. And individuals may be weeded out of the system because there's, a couple of things. It could be a lack of evidence that they committed a crime, or because a police officer, prosecutor, or judge or jury, exercise their discretion. And this is an important word. That's why it's up there. And decides that there is little social interest in continuing to subject a person to the criminal justice process. And the police may decide not to arrest a person. A prosecutor may decide not to file charges, or to file something less serious, or maybe to enter into what they call a plea bargain. The jury may acquit a defendant, or a judge may determine that the offender merits a lenient sentence. So all of these things fall into this realm of this word that's important because it fits into all those areas. Discretion, the freedom to decide what should be done in a particular situation, to arrest or not, to prosecute or not, etc. So these are very, very important terms as we start to look at the criminal justice process. So here is kind of a quick outline, and we're not going to spend a lot of time on this, but the bigger pieces, if you will. And it's on page 3 in your text because I totally know you're following along. But the first part of the process is the investigation. The criminal investigative phase involves detecting and investigating criminal offenses. And then after that could come an arrest once the police have established that there is probable cause to believe that a crime has been committed and that there is, again, probable cause, we call it PC, to believe that this person has committed the crime. They are authorized to arrest. Now, if you go back to those burdens we talked about, remember, to arrest, you need probable cause. So see, you've kind of put those two things together. Now, after you get arrested, well, what happens after that? Well, it's kind of the post-arrest thing. So an individual who has been subjected to a custodial arrest, meaning arrested, will be booked at a police station or jail. And this phase involves recording information regarding the arrestee, taking, let's say, a mugshot and fingerprints, and an individual may be subjected to an inventory of their property. And we'll talk more about that as we go further. We'll find some of this in chapter 5, 6, and even 12 when we look at searches. Here we're just kind of going over some of the bigger pieces of the process. Now, the post-arrest investigation, following an individual's arrest, the police may continue to follow up on investigative leads and engage in investigative activities designed to gather more evidence against the suspect to determine their level of guilt. So even though a person's been arrested, the post-arrest investigation could keep going while that person is in custody. Okay, so it's important to know that. And then next will come the criminal charge. So prosecutors have the discretion to formally charge suspects with criminal offenses or not to file charges and release the person from custody. And prosecutors who decide to pursue cases file what we call complaints that describe all the alleged crimes and the relevant sections of the criminal code. So it's important that when they file those charges that all of that information is in there. Now, suspects are then brought before their first appearance before a magistrate. A lawyer is appointed, and they are informed of the charges against them and of their right to remain silent and counsel, etc. And again, lawyers are brought into play here, and bail is fixed. So just, again, this is some of the kind of things that happen here as we go along. Next would be the pre-trial. So the next step in some jurisdictions is what we call a preliminary hearing. And this is where a judge determines whether there is probable cause to believe that the defendant committed the crime charged in that complaint. It's kind of like a little mini trial. And this is where the prosecutor presents witnesses, not all of them, but they may be cross-examined by the defense. And this little mini trial also allows the defense to learn some of the evidence that will be used at trial if it goes that far by the prosecution. And the defense can also file a motion for discovery, which means that the prosecutor would have to turn over information to the defense if it is in the defendant's favor. So that's part of the little pre-trial thing. So again, pre-trial motions, defense attorney can file a lot of different pre-trial motions. They include things like a motion to dismiss the charges, maybe because the defendant was already tried for this offense, or they were denied a speedy trial, or maybe somebody seized evidence unlawfully. During these pre-trial motions, the defense attorney could bring that up. If the judge grants it, then the case will be dismissed. But if they don't grant it, then things will continue on. And the next step in that continuing thing that we're talking about would actually be the trial. And the accused is guaranteed a trial before a jury in the case of a serious offense. A jury trial is generally composed of, at least in California, 12 people Most states require a unanimous verdict, and there was a case that I saw on the news not too long ago that talked about unanimous verdicts, because in the past there have been some states to where you didn't need all, if it was 10 jurors, all 10, if it was 12, all 12, to be unanimous in order to convict. But there has been a case that has changed that, and the name of the case kind of escapes me right now, but just know that. And again, so after the trial, you will have sentencing. So following a criminal conviction, the judge holds a separate hearing. It's called a sentencing hearing, and establishes the defendant's punishment. There are various types of punishments available. To the judge, it could be incarceration, it could be fines, it could be probation, it could be a combination of things. So those are all available. Remember, for felonies, that you have the right to appeal. That could be the next step, where a defendant has the right to file an appeal to a higher court. The U.S. Supreme Court and state Supreme Courts generally possess the discretion to hear a second appeal, but typically it's one appeal. And then finally, post-conviction, meaning what happens now? Well, individuals who have been convicted and have exhausted all their appeals may file a motion for post-conviction relief, as they call it, in the form of writ of habeas corpus, claiming that the appeal court made an error. But if that doesn't work, then that post-conviction will move into the correction side, and the individuals will be sentenced, and that will be it. So just, understand that criminal procedure defines the steps to be followed by police, prosecutors, defense attorneys, judges, and jurors at each stage in that criminal justice process, and also addresses the rights of criminal suspects and defendants. And we'll talk about some various sources of criminal procedure right now. So where do we find some of that? The law regarding criminal procedure can be found from various sources. Well, the first one is the U.S. Constitution, and the U.S. Constitution is called the supreme law of the land and is the central source of criminal procedure. And I want you to think about why. You don't have to answer right now, of course, but I'd like you to kind of figure out, why is the Constitution the supreme law of the land? And who analyzes that? Who can interpret what the Constitution is saying? Well, that would be the Supreme Court. Anyway, let's move on. Judicial decisions. The U.S. Supreme Court has the final word on the meaning of text, not like texting with your phone, but text like written things. An example would be what is meant by unreasonable search and seizure. Well, when that is written in the Fourth Amendment, who determines the meaning of what is unreasonable? Well, the U.S. Supreme Court. So judicial decisions, the U.S. Supreme Court, they're the ones, those justices will define the words or the meaning of the text. Next would be state constitutions. If you don't know, every state has a constitution. So state constitutions all contain provisions for addressing criminal procedure that are similar to the provisions in the U.S. Constitution. Common law. English common law formed the primary basis of American law and justice in the 17th and 18th centuries. Some states still accept a little bit of common law, most don't. California does not. However, know that a lot of sources of procedure and law came from common law. Some other sources of procedure could be legislative statutes, meaning these are laws that regulate various aspects of criminal procedure, both state and federal guidelines. There are court rules. The U.S. Congress has authorized the U.S. Supreme Court to formulate federal rules of criminal procedure, kind of a roadmap for the justices to follow. So there are rules of the court. There are agency regulations, meaning that law enforcement agencies, they have their own regulations. So let's just say if they were going to do a photo lineup and show a victim a picture, there are rules that the officer would have to follow in order to make it accurate and fair. So those are agency regulations. And then there is something called model code. Now, model codes, this is where we have a group of judges and lawyers and law enforcement professionals, and they've drafted what we call the model code of criminal procedure, or in this case, pre-arraignment procedure, to help set standards for things like street encounters prior to formal arrest, etc. So states can look at these model codes and take some of those codes and implement them into their own agency regulations, court rules, or legislative statutes. So these are what we call model codes. So hopefully that kind of makes a little bit of sense on everything that I've gone through. So again, our study of criminal procedure primarily will involve reading federal and state legal decisions. And as we go into the next section that we're going to talk about, we're going to look at the structure of federal and state courts. Now, on the federal side, and I've got some diagrams here to kind of help you out. The federal judicial system, the United States has a federal system of government in which the Constitution divides powers between the federal government and the 50 state governments. And as a result, there are what we call parallel justice systems. The federal courts address those issues that the U.S. Constitution reserves to the federal government, while state courts address issues that are reserved for the states. And we'll break those down a little bit. So what do I mean by parallel judicial system? Well, again, federal courts address those issues that the U.S. Constitution reserves to the federal government, while state courts address issues that are related to states. And concurrent jurisdiction means there's a joint authority of federal and state courts in certain areas, such as claims under federal civil rights law, etc. And this means an action may be filed in state or federal court. So, just for information. So, again, the U.S. Supreme Court has recognized the concurrent jurisdiction or joint authority of federal and state courts over certain areas. And this means an action can be filed in a state or federal court. Now, here you can look, I have a diagram to the right where you can take a look at kind of a quick down and dirty look at the federal court system versus the state court system. And I have a couple other charts for you to look at. So if you look at the state, you have like your county courts, your municipal traffic courts, etc. Then you have, and this could be different from state to state. This is kind of the general outline. Then you have like juvenile courts or family court. Then you have superior courts. And these courts hear serious cases. And this is where most of the trials are. And this is typically where you may end up testifying as a law enforcement officer for a felony case. If you make an arrest, you'll go to superior court. And then the top state court is the state Supreme Court. Now, don't get confused, because up here you see another Supreme Court, okay? But they're different. Every state has a state Supreme Court. The highest court, though, in the land, we know, is in the federal system, and that's over here. Now, when we go to the federal side of the house, the lowest courts are the district courts. And these hear cases related to violations of federal law. Then you have like tax courts. These are special courts. And then you have the Court of Appeals. And these appeals, these are challenges to orders from federal agencies, etc. Or if somebody wants to appeal their case. And then finally, you have the U.S. Supreme Court, which is the highest court in the land. This is it. You can't go any higher. And they hear cases Very few, basically. You know, if they receive, say, 7,000, they may only hear like 150. But these are appeals on cases of constitutional issues, search and seizure, unlawful detainment, different things like that, constitutional issues. Okay, so here's another kind of example of the federal court system. And there's some videos. Remember, if you went through the module through week 1, you found an area that had the court systems. There's videos in there that talk about each one of these. So district courts, lowest level in the federal system. And you can look right here. You have the circuit courts, or the Court of Appeal. Okay, sometimes they have a different name, but circuit courts, Court of Appeal, these are the intermediate courts. Then you have the Supreme Court, the U.S. Supreme Court, highest court in the federal system. 9 justices in Washington, D.C. Circuit Court of Appeals, just to kind of give you a little more background on that, they sit in 3-judge panels. In certain important cases, all of the judges in the circuit will sit what they call en banc, or in bench, and the decisions of a court of appeals are binding on the district courts within the court circuit. So if we go back and we look at this, go back real quick, if this court made a ruling and it went up to the Court of Appeal can overturn, if this court made a ruling, start at the bottom, and it goes up to the Court of Appeal, the Court of Appeal can override, if you will, or overturn the lower court. Same if it went to the Supreme Court could actually overturn the Court of Appeal. Does that make sense? Okay. Now, the U.S. Supreme Court, a little bit of information, sits at the top of the hierarchy of the federal and state courts. It's called the court of last resort because it is. There's no appeal from a decision of the Supreme Court. 9 justices appointed by the president. And this last year or so, we've seen a couple appointed by the current president. The Supreme Court's decision, they set, remember that word, precedent, and is the binding authority on every state and every federal court in the U.S. So if the Supreme Court makes a case precedent decision, everybody has to follow it. So the case, just kind of looking here, Terry versus Ohio, this is the stop and frisk, the pat down. They made a historic Supreme Court decision on that case. And if another court gets a similar issue, they need to follow the precedent set by the U.S. Supreme Court. So in other words, any court in the country that hears a case involving an issue on which the Supreme Court has already ruled is required to follow the Supreme Court's line of judgment. That kind of plays into what we talked about earlier. That precedent is based on what we call stare decisis, which means in Latin to stand by the precedent, okay, and to stand by settled points, those points that the other court already ruled on. And this use of precedent in the legal system gives the Supreme Court, the U.S. Supreme Court, power to influence and mold the everyday operating procedures of the police. What do you think happened when Miranda versus Arizona came out and now law enforcement had to read suspects their rights before they question them? Do you think that changed the way that police did what they did? Absolutely it did. And I sound excited because it kind of is. Now, I wasn't a cop way back when that happened, but it still impacted me in my career, knowing that these are precedent that I had to follow. If you want to know a little bit more on the Supreme Court, I have a link to a video that you can watch talking a little bit more about the Supreme Court. So, a couple more things and we'll move on. The U.S. Supreme Court consists of a Chief Justice and 8 Associate Justices, so 9. The court reviews a limited number of cases. In an active year, the Supreme Court may rule on about 150 of the 7,000 cases it is asked to consider. Remember, they deal with a lot of constitutional issues. All right. The court also, the U.S. Supreme Court, has what we call original jurisdiction over disputes between the federal government and a state and between states. The court may hear an appeal from the decision of the Court of Appeals. The Supreme Court also will review state Supreme Court decisions that are decided on the basis of the Constitution. Now, for judges to hear a case, 4 judges must vote to grant what we call a writ of certiorari. And it's hard to say, and it's harder to spell. And it means to have a decision reviewed. So when these cases come up, 4 of the judges must vote in favor of granting this writ in order for the United States Supreme Court to hear a case. And again, here's kind of a, when we talk about writ of certiorari, it's by definition a request for a transcript of the proceedings of a case for review when the Supreme Court decides to hear a case, so they have to approve it. And here is, in the Supreme Court of the United States, this is one where we have a petition for a writ of certiorari. And this is the, Donald Trump, president, versus Ryan Karnosky, and we won't look at that, but this is what a petition looks like. There's more to it, but this is part of it. If you want to know a little bit more on how a case gets to the Supreme Court, I have a link down here at the bottom, and you can take a peek. So the U.S. Supreme Court requires lawyers for the opposing sides to submit what they call a brief, or like a short written argument. And the court also conducts oral arguments in which the lawyers physically present their points of view and are questioned back and forth by the different justices in order to get clarification. The party appealing a lower court's judgment is called the appellant, and the party against whom the appeal is filed is called the appealee. So a couple of definitions. And 5 of the Supreme Court justices are required to agree, again, if they are to issue what they call a majority opinion. And this decision will constitute, remember what we talked about, legal precedent. An example, Miranda versus Arizona. You don't always see 9-0-8-1. You're going to see some 5-4s and 6-3s and things like that. So a lot of times there's some close ones. But 5 of the justices are required to agree if they are to issue this majority opinion, if you will, such as in Miranda versus Arizona. All right, so quickly, we talked about the Fed. What about the states? Well, there is a significant variation among the states in the structure of state court systems. Prosecutions are typically first initiated or originate in the court of original jurisdiction. There are 2 types of courts in which a criminal prosecution may originate: court of limited jurisdiction and courts of general jurisdiction. And we'll kind of take a look at those in just a second to try to figure out what exactly those mean. But we'll get right down to those. Okay. Limited jurisdiction, those are things like municipal courts, police courts, or magistrate courts, typically low-level cases. Now remember, this is U.S.-wide we're kind of talking about, so they're all a little bit different, but mostly the same. All right, so typically low-level cases, things like misdemeanors, traffic, and some other specified. Now, general jurisdiction, these are where more serious felonies are heard. And these are sometimes called trial or superior courts. Okay, it depends what state you're in. And this is where officers, again, would most likely testify in these trial courts. And when you talk about state courts, again, there are intermediate appellate courts for state. So if you're at the trial court back here, well, I guess we're going to get to that. You can, if you don't like what happened at the trial court, you can move up to the intermediate appellate court. So under that, these courts hear appeals from courts if general jurisdiction are taken in 40 of the 50 states to intermediate appellate courts. And then the court above that would be state supreme courts. Okay. And you have a state court judge selection process. When you talk about state court judges, remember there's a variety of ways in the state. They're not always they're not elected by the president. There's a variety of ways state court judges get put into office. Could be elections, like on the ballot, or state legislature, or even appointed by the governor. So when we look at exactly how this kind of goes, here we go. When we look at the state courts, and again, they're a little bit different, but you have the trial court. That's the lowest level. Then you have the Court of Appeal. And then you have the state Supreme Court. It's not the U.S. Supreme Court, so don't get, or it could be Superior Court. Okay, trial court, Superior Court, it just depends where you're at. Court of Appeal, and then the state Supreme Court. So again, there are ways for individuals to appeal their case. If you want to look at them side by side with a little bit more detail, you can see the state court on this side. We have the trial courts with, like misdemeanors. Then you have the Superior Court, which they called it the trial. Then they have the Intermediate Court of Appeals. Then they have the state. Okay, then down here you have district courts. Then you have the Circuit Court of Appeals. Then the U.S. Supreme Court. So you can kind of get a look at how all that works. Real quick, finishing up with precedent, and then we'll talk about judicial philosophy, and we'll be done. We have seen that courts follow that stare decisis thing. Think about the advantage. What would be the advantage of having other courts follow precedent? I kind of just keep that in your mind as we go through. Well, one of the advantages here is that courts do not have to kind of reinvent the wheel each time they confront an issue, because hopefully another court has already done that, and they can go off of that court precedent. When it comes to precedent, courts have varying degrees of authority to apply precedent. As noted, the U.S. Supreme Court decisions constitute precedent for all other courts. Courts of appeals and state Supreme Courts have established binding precedent within their jurisdictions as well over the lower courts. In other words, a state Supreme Court decision constitutes precedent for all other courts within that state, because that's the highest court in the state. Does that make sense? Okay, watch those videos to kind of help you. But what if there is no precedent? Well, there's a couple of ways that we kind of figure this out. First is what they call first impression. If there's no other precedent, the courts will look and see what other courts have decided. They also have something called persuasive authority. These other decisions do not constitute precedent, but they're to be considered in making a decision, meaning that maybe there was some other law or authority there. And then finally, binding authority, meaning it is what it is. The Supreme Court of California has binding authority over all other lower courts. So again, this is talking about precedent. Okay, finishing up with judicial philosophy, and we'll be done. The U.S. Supreme Court decisions, again, are the central source for interpreting the U.S. constitutional provisions addressing criminal procedure. These decisions cover areas ranging from search and seizure to interrogations to the right to an attorney. There have been some shifts in ideology, and meaning that there have been some changes, and this has been reflected in different justices' attitudes towards crime and criminals, but mostly in instances where new justices are being appointed to the bench. So a lot of times when you have a new justice come in, the court may shift a little bit in their ideology. So maybe they were super conservative and maybe it shifts, or maybe they weren't conservative and a new justice comes in and they kind of shift. So sometimes there's a shift in ideology. And some courts are even named after the Chief Justice. Scholars tend to refer to the name of the Chief Justice as shorthand for describing that shift in philosophy of the Supreme Court. So an example would be the Warren Court. This was the liberal Warren Court. And so instead of saying, citing the dates when the court was in and all those people in it, people would refer to it as the Warren Court, meaning it was liberal, or they would say the Burger Court, meaning that it was more conservative, and that was when Warren Burger was the Chief Justice. Keep in mind, a lot of times we talk a little bit about the labels, that the use of labels like liberal and conservative to describe justices may not be fully accurate in every single instance. A liberal justice who believes in individual liberty also may be tough on crime, and a conservative justice who opposes, let's say, abortion also may be an absolutist when it comes to freedom of speech. And there are other issues where a justice's point of view is not easily categorized on the liberal or even conservative side. And history has also demonstrated that justices have changed their philosophy while serving on the court. So just kind of keep in mind that there are some differences, but labels are things that we got to just be careful of. All right, so let's talk about some areas of judicial focus, and then we'll wrap up. The first one is federalism. This is where some justices stress that the state should be free to follow their own approach to criminal procedure. And some believe that it is best to have the same system of criminal procedure in the federal courts and in all 50 states. The term precedent, again, justices differ in their willingness to deviate from prevailing precedent. There's a term called bright line rules, and this is where justices may view their decisions as opportunities to establish general rules to guide the police and lower courts, and other justices limit their decisions to specific facts of the case before them and do not formulate general rules. So these are all areas of judicial focus for us to kind of understand. Police power. Some justices have greater trust in law enforcement and are willing to expand police powers, while others favor a tighter legal control. State of mind. A related question is whether to use an objective or subjective standard in evaluating the conduct of the police or other criminal professionals. So, I mean, it's kind of an interesting thing on how these different justices kind of look at those things. Interpretation. In interpreting the U.S. Constitution, originalist justices are guided by the intent of the framers of the document. Justices who believe in contextualism tend to interpret the Constitution in a broad fashion and argue that the Constitution is a living document, so it needs to meet the needs of today's society. Thus, could it alter it? Or their interpretation of that. Separation of powers. There are justices who are reluctant to hold unconstitutional the decisions of elected executive and congressional branches of government. And there are some that go the other way. Consensus. Some justices make an effort to create consensus and reach a single majority decision, while others are more willing to dissent from the other justices on the court. And then finally, psychology. Hey, justices are only human, and their decisions in some instances may be influenced by their own individual experiences and background. So again, these are all areas of judicial focus. So as you read the text, keep in mind again that although the American criminal justice system affords defendants a long list of rights and protections, there is a difference between law on the books and law in actions. Defendants may choose to plead guilty, waive their constitutional right to challenge an unlawful search, or waive their right to be tried before a jury. Defense attorneys may not vigorously defend their clients. Prosecutors may choose the right to charge some defendants with criminal offenses while dropping the charge against other defendants charged with the same crime. There also is the unfortunate fact that sometimes law enforcement and other criminal justice professionals may abuse their authority, and people may fail to abide by the letter of the law. Keep in mind that the exercise of discretion is not necessarily a bad thing. Example, a police officer's decision not to arrest a juvenile, or a prosecutor's decision to offer a light sentence to a first-time offender in return for a guilty plea may be a way of achieving justice. So again, law in action and law on the books. Okay, so we almost made it within 60 minutes. That's typically how I like to keep it. We're just a little bit over, but that's okay because it was awesome, and I hope you think it was as well. So a couple of quick housekeeping things. Please make sure that you read the chapter in your textbook. Take the time to go through the module and do the key terms, matching assessment exercise. It's not graded, and you can take it as many times as you want so you can learn more of the definitions. Also, review the questions at the end of the chapter because that's important to help you kind of get a better understanding about what we're talking about. And then finally, don't forget the court videos that were in the first portion during week 1 that talk about the different courts. With that being said, that will conclude our lecture for Chapter 1, Introduction to Criminal Procedure. Until next time.